welcome to Crime in Court. My name is Heather and this is another Delphi video. We have motions flying back and forth between the state and the defense, and even Judge Gull wrote an email to them. So we're going to get into all of these things in the next few videos. I'm spacing them out because there's just so many of them and they're all different topics. So I kind of want to keep them separate, and then, well, especially this one because all my Frank's videos are in their own separate videos. So this is the fourth Frank's request from the defense. They have been denied without hearing. They've been kicked off the case for trying to get a Frank's hearing. And here they are for the fourth time trying get a Frank's hearing. And basically a Frank's hearing is a hearing to present evidence that you feel would be relevant and important for your case in the trial, which might not actually, it's not already stipulated by both sides that it's coming in. So this, if they've got this Odinist theory and all this stuff, then they might want to bring forth, because they, if they're pointing fingers at anyone in particular, which in their Frank's memo they have, they need to have evidence to back that up. So that's what a Frank's hearing would be, is for them to present all the evidence that they've talked about in the Frank's memo, or not all of it, but at least, a good portion of it, to the judge to say, oh yeah, okay, there is something here, let's explore it more, it can come in at the trial. So that's my understanding of what a Frank's hearing is. If anybody has more to add to that, that would be great in the comments. Before we dive in, please hit the like button. And also I want to let you know, if you are new to my channel, I have gone through all of the Frank's motions before. They are in the description below if you want to start from the beginning and read all of the Frank's motions. So here we are with Frank's motion number 4, like I said. And I'm sorry, it's kind of blurry. A lot of these motions come to me as like images in a thread, and I have to take screenshots of them, and sometimes they're blurry. It's blurry to me. It's probably blurry to you guys too. All right, so comes now the defendant, Richard Allen, by counsel Andrew Baldwin, Bradley Rosie, and the new counsel Jennifer Auger, and for his motion to compel states as follows. General background. On September 18th, 2023, Mr. Allen, by counsel, filed his first Frank's notice, herein the Frank's number 1, which included a 136-page memorandum in support of the notice. We did it in, I believe it was 9 parts on my channel. I tried to keep it around an hour each. So yeah, you're in for a ride. If you like to binge some things and you haven't read the Frank's memo, go for it. All right, so this memo detailed the following. A. Certain evidence that Carroll County Sheriff Tony Liggett failed to include in his search warrant application for the residence of Richard Allen under cause number blah blah blah, herein the search warrant. All right, so B, certain evidence that was detailed in his search warrant applicated for the search warrant that was false. And C, evidence that law enforcement had acted in an intentional manner on multiple instances, attempting to conceal evidence from the defense and failing to tell the truth under oath concerning certain evidence. So you lied. You tried to conceal evidence from the defense. You lied in your application for the search warrant. And what else? That was it. Oh, certain evidence that Tony Liggett failed to include search warrant application for the residence. All right, so number 2. So that's a lot. There's a lot of things that are like almost misconduct worthy, or at least should like call for a new trial or a new, dropping the charges and reevaluating. I don't know. Number 2, Mr. Allen, by counsel, incorporates his first Frank's notice and memorandum filed on September 18th and is fully outlined herein. Number 3, on October 3rd, 2023, Mr. Allen, by counsel, filed his Frank's notice, herein Frank's 2, detailing how the prosecution and law enforcement had attempted to conceal the identity of a Purdue professor whose testimony contradicted that of law enforcement officers Tony Liggett and Jerry Holman of the Indiana State Police. This notice was provided as a supplement to the first Frank's notice in order to bolster the defense contention that the state of Indiana and law enforcement were acting intentionally and or with reckless disregard of the truth to further support the request for a Frank's. I mean, I think that's pretty self-explanatory, but basically Tony Liggett and Jerry Holman from the Indiana State Police lied in their testimony, saying they knew nothing about this Purdue professor. They can never find them again. Their identity is a mystery. We'll never know. And they filed their Frank's memo, and very shortly after, this secret Purdue professor who claimed that the pictures could be from some kind of ritualistic something and that the sticks on them were formed as runes, he confirmed those things. Tony Liggett and Jerry Holman lied and said there was no such connection. So that's important. That's important. And Judge Gull is just ignoring this. I mean, that's enough to get you fired, or at least demoted, and go through some more training about what law enforcement can and can't do. That would be my opinion. But anyways, or just take them off the force altogether, because they're not trustworthy. Number 4, Mr. Allen, by counsel, incorporates his second Frank's notice filed on October 3rd and is fully set out herein. Number 5, on October 13th, I'm sorry, we're going to get October. On March 13th, 2024, Mr. Allen, by counsel, filed his third Frank's notice, herein Frank's 3, based on evidence recently provided by the prosecution. Frank's third, detailing the following information omitted from the search warrant. So before I read all of those, I do have a video of the Frank's second and third motions are combined in one video, and there are timestamps so you can like skip to whichever one you want to listen to. So those are combined in one, and then my Frank's motion, the first one, is in 9 separate parts, all listed below in the description if you want to read it again or haven't read it yet. All right, so they are saying in their Frank's notice number 3, which was filed in March, these things were omitted from the search warrant. A, at least 3 persons were in or around the crime scene at the time the unalivings were allegedly taking place, and none of the owners of the phones had any connection to Richard Allen. And B, Purdue professor Jeffrey Turco wrote in a report provided to Unified Command that the markings referring, so this is they finally get the professor, and now this is what the professor actually said. The markings referring to the configuration of the branches on the girls' bodies constitute an inscription inspired by Norse runes or modern recreations thereof. It is quite plausible. So the markings constituting something having to do with Norse gods, Norse runes, or something more modernized, it's very plausible that these things are for ritualistic sacrifice or something along those lines, and these are Norse runes. They don't say specifically ritualistic sacrifice, but they do say, at least in this portion that they're providing us, that it is plausible. All right, number 6. Mr. Allen, by counsel, incorporates his third Frank's motion filed on March 13th and said here. Okay, so all of those are included in this document, Judge, because you haven't read them the first 3 times that we gave them to you. We are now on our 4th. We're summarizing what each of them are, just for your convenience, because we know you're not going to read the 136-page document, because you've already admitted to the world that you didn't read it. Anyways, so yeah, here are our previous Frank's memos. They are accounted for in the attachments, and guess what? Here's what they are. Now, Judge, here's some additional facts that might help you in your decision making. On Friday, April 26, 2024, the prosecution provided numerous documents. So this is last week. I gotta plug my computer in. It's not dying or anything. I just don't want it to while I'm streaming here or recording. Sorry. All right, so literally this past week, the defense the state just gave them more discovery, like loads and loads. They just keep piling on. We went through that in another that was for the request for sanctions for Nick McClelland, and how he just keeps piling on more and more discovery that's not even related to the case. All right, so number 7. On Friday, April 26, 2024, the prosecution provided numerous documents to Mr. Allen's counsel as a result of the motion to compel and motion for sanctions filed on the 23rd. So because you haven't turned these things over, now you did, because we called you out on it again and again and again, and we asked for sanctions. Number 8. Contained in the documents provided by the prosecution are pages 2 and 3 of an incident report authored by Steve Mullen of the Delphi Police Department. Steve Mullen, if you have been following my channel and all the many Delphi videos that come out because there's so many filings, we got the transcript of the contempt hearing for Allen's attorneys Baldwin and Rosie. And in that contempt hearing, Steve Mullen was one of the individuals who testified and was questioned by Hennessy. However, he was called back too by Hennessy. So he was a key witness in that. All right, so number 9, the 2 pages indicate that Steve Mullen, so pages 2 and 3, indicate that Steve Mullen contacted Sergeant Mitch Blocher, I don't know, of the Indiana State Police at approximately 9 p.m. on February 13th, 2017. So the night of the incident, when the girls disappeared, Steve Mullen contacted this Sergeant Mitch Blocher, and he asked him to assist with acquiring precise location information for a cell phone using some of their more technical assets. It appears that the last communication with Sergeant Blocher was prior to 1 a.m. on February 14th, 2017. Number 10. The 2 pages provided to Mr. Allen's counsel contain the following summary of a conversation between Steve Mullen and Sergeant Blocher of the Indiana State Police. Sergeant Blocher advised, according to his evaluation of the data provided by AT&T, The last contact event between the cell phone and the tower located at Wells Street was at 17:44:50 hours. He advised that according to the records provided by AT&T, there had been no contact with the phone since then. Sergeant Blocher advised that his interpretation of the information which we were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in working condition. He advised that since there had been no change in the every 15 minutes updates we were receiving and the last known contact time had not changed since 1744. Number 11, the conversation above appears to have occurred prior to 1 a.m. on February 14th. 12. On February 9th, 2023, the prosecution provided Mr. Allen's counsel with evidence of 44 pings generated by AT&T to locate LG's or Libby's phone herein. The pings. 13. There were 2 pings from February 13th, 2017 in the pings provided to defense counsel, one at 5:48 p.m. and another one at 7:16 p.m. Mr. Allen's counsel did not learn of additional pings which took place every 15 minutes on February 13th, 2017 until the discovery disclosure on April 26th, 2024. Defense counsel still does not have the additional pings from the February 13th, 2017 or the early morning of the February 14th. Pursuant to the information which the prosecution disclosed to Mr. Allen's counsel, the first ping on February 14th was sent to LG's phone at 5:39 a.m. Why are these pings? The first ping was sent on LG's phone at 5:39 a.m. And there were how many? Every 15 minutes. Weird. Okay. So 15. More importantly is Sergeant Blocher's statement that his interpretation of the information which they were receiving from AT&T indicated that the cell phone was no longer in the area or no longer in working condition. And that's bolded because, yeah, why would he come to that assumption? Or interpretation, as they say. Number 16, the prosecution's entire case rests on the idea that LG and AW, so Libby and Abby, were on or near the south side of the Monon High Bridge at 2:13 p.m. and that Richard Allen ended their lives between that time and when a witness allegedly saw a man in jeans and a blue jacket on 300 North shortly before 3:57 p.m. In other words, assuming the prosecution's evidence is accurate, LG and AW had their lives taken after 2:13 p.m. and before 3:57 p.m. on February 13th, 2017. Additionally, assuming this timeline is accurate, the prosecution would have the girls between the Monon High Bridge and the location where the bodies were found from 2:13 p.m. on February 13th, 2017, the bridge video, until they were found at approximately 12:15 on February 14th. Okay. Number 18, at the time that the bodies of AW and LG were found, LG's phone was under LG's shoe, both of which were under the body of AW. So Libby's phone and her shoe were both under Abby Williams' body for some reason. So why is it still pinging all those times? I don't know. Okay. So assuming the prosecution's timeline is accurate, LG's phone was under LG's shoe, which was under the body of AW from some time after 2:13 p.m. on February 13th, 2017, until the bodies were found at approximately 12:15 p.m. on the 14th. and had remained at that location in the condition for that entire time. And here, what they're getting at is they weren't laying there that whole time. They likely weren't, they didn't have their lives ended until a much later time. I think it's much more likely. All right, so number 20, however, Sergeant Blocher stated on February 13th that the cell phone was no longer in the area or no longer in working condition. 21, there is no way LG's cell phone could have been out of the area between 9 p.m. on February 13th and 1 a.m. on February 14th. So her phone was not in the location that the state is claiming it to be from 9 p.m. on until 1 a.m. If the prosecution's timeline is accurate, because the phone was at the location where the bodies were found that entire time, so 2:15 versus 9 p.m., there was a big difference. Assuming the prosecution's timeline is accurate, there is no way that the phone was not in working condition between 9 p.m. on February 13th and 1 a.m. on February 14th, because we know the phone was on and communicating with the cell phone tower at 4:30 a.m. on February 14th. Those girls were abducted and taken somewhere, potentially waiting for other people to arrive or for whatever. So I feel like they were being held somewhere until a later time when they took their lives. That's my opinion. And I'm basing that on just the facts that I know so far. All right, so we know that where they were found was not the crime scene. That was not where their lives were ended. So they had their lives taken somewhere else and were probably moved in those areas that they were found. Anyways, all right, so where did I leave off? For the prosecution's timeline to work, phone had to have been in the same condition from sometime prior to 3:57 p.m. on February 13th, the time that the witness sees the man on 300 North, until the time that the bodies were found. Number 23, and the time of the search warrant for Mr. Allen's residence, members of the Indiana State Police were also aware that the last ping of LG's phone was not at 5:44 p.m. on February 13th, but it was 4:33 a.m. on February 14th. Furthermore, it is evident from the data from LG's phone that the phone was accessed and connected with the cell phone tower at 4:30 a.m. on the 14th. 25. Had Tony Liggett submitted an affidavit for the search warrant that did not recklessly disregard the truth, it would have included the following. So if he would have done his job, basically, this is what the search warrant should have said. When the bodies were found at approximately 12:17 on February 14th, there were sticks and branches which appear to have been deliberately placed on the bodies. B. FBI Special Agent Nicole Robertson stated that the bodies appear to have been moved and staged. Like I said, their lives weren't ended there. And they were staged because Abby had Libby's clothes on and Libby was nude and there were branches all over them. C. At the time of the unalivings, AW was dating Logan Holder. D. Logan Holder is the son of Brad Holder. So there's your connection. E. Jerry Holman of the Indiana State Police consulted with Professor Jeffrey Turco of Purdue University. F. Purdue University Professor Jeffrey Turco wrote in a report provided to Unified Command that the markings, referring to the configuration of the branches on the girls' bodies, constitute an inscription inspired by Norse runes or modern recreations thereof, is quite plausible. So like I said, that's what they think it could be. G. In 2017, Brandholder belonged to a group participating and following Nordic pagan beliefs. I mean, you can't have more guilty connections than these people. Brandholder, Elvis Fields. I mean, all of these people should be going to trial, not Richard Allen. AW and LG had their lives ended after 2:13 p.m. and before 3:57 p.m. on February 13th to the 14th. During that time, so that was the 13th, 2:13 to 3:57 p.m. During that time, there were 3 phones in the area where the girls were last seen and the location where the bodies were found. None of these phones belonged to Richard Allen. K. On February 13th and 14th, 2017, law enforcement requested AT&T's ping LG's phone. Law enforcement asked them to ping her phone every 15 minutes. That's what that was about. Okay. So I guess AT&T has the ability to do that, so you can help find it. I did not know that. All right, so the time of the last ping to LG's phone on February 13th was 5:44 p.m., and the time of the first ping on the 14th was 4:33 a.m. L, I think you're right. Yeah. Okay. State police believe that LG's cell phone was either out of the area of the Wells Street Tower or not in working condition between 5:44 p.m. on February 13th and 4:33 a.m. on the 14th, at which time there was a successful ping to the phone. 26. These omissions are so voluminous and significant that there is no explanation for their omission other than a reckless disregard for the truth. 27. Had Tony Liggett not recklessly withheld pertinent information from his probable cause affidavit on the search warrant, the application would have been denied. Wherefore, Richard Allen, by counsel, respectfully requests the court set this matter for hearing, grant Mr. Allen's motion, and exclude all the evidence seized as a result of the search of Richard Allen's home and for all other just and proper relief in the premises. So that is signed Andrew Baldwin, Bradley Rosie, and Jennifer Auger. So that's pretty wild stuff. I mean, it's nothing new that we really didn't know, but it is, we didn't know about the phone pings. So that's interesting. They're trying to claim that a period of time in between the unalivings and when they were found, that it was, that their phones weren't working, when I think maybe the perpetrator had their phones and were using them or something. I don't know. What do you guys think? Maybe they went through her... Well, no, because we know that they didn't delete the Bridge Guy video or anything like that. So if there were videos of Abby, or of, on Libby's phone, if there were video or pictures of these perpetrators that were doing this, I would think that they would remove them from the camera or video thing before, law enforcement gets it. But you know what? I don't know, because you also have an Elvis Fields who asks law enforcement, if I spit on her and I have a good reason, do I have to go to jail? So, yeah, I don't know. I don't know. That I do know was the fourth request for Frank's hearing on newly discovered evidence about the phone pings, because they didn't know that before. So that is another reason to tally up against all the reasons why there's probably some kind of Odinist ties and something just isn't right over here. But yet, Judge Gull is probably just going to be like, denied without hearing. That's my guess. What do you guys think? Let me know in the comments below. Please don't forget to like this video and subscribe. Make sure the notification bell is on, and I will see you in the next one. I appreciate you guys so much for watching. Take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.